Since there is a very real possibility that criminal justice personnel may at some time become injured during the course of their careers, it is important for managers and administrators to consider issues related to the employment rights of disabled officers. This is a very important issue that is worthy of much discussion and consideration. First, let us discuss the passage of the Americans with Disabilities Act of 1990. As you may know, in 1990, Congress passed the Americans with Disabilities Act, which prohibited discrimination in employment-related matters. While many members of Congress believed that this new federal law would fundamentally change employment matters related to disability, much to their chagrin, the United States Supreme Court, as well as other federal courts, took an extremely conservative approach in interpreting the Americans with Disabilities Act. The court eroded almost all of the protections of at least the federal laws concerning disability discrimination. As a result, plaintiffs seldom prevailed in ADA cases. Just to give an example, in 2002, the American Bar Association released a survey indicating that employees lost 94.5% of ADA cases in federal court. In 2008, Congress reacted to the decisions of the U.S. Supreme Court, and it passed the ADA Amendmentws Act of 2008. This essentially reverses most of the previous decisions of the United States Supreme Court. As mentioned earlier, the court was extremely conservative in interpreting the ADA of 1990, but the Americans with Disabilities Act of 2008 covered much more instances of disabilities. For example, under the former ADA of 1990, most disability claims were lost by employees because they were able to take corrective actions. Therefore, the court reasoned that there was no disability. For an example, an employee under the ADA of 1990 with poor vision had difficulty succeeding in an ADA claim if he or she wore corrective lenses, which essentially provided normal vision. So in essence, under the old Americans with Disabilities Act, virtually all employees with treatable impairments were not considered to be covered by the ADA. As a result of the court's interpretation, federal courts under the Americans with Disabilities Act of 1990 routinely dismissed claims where individuals had either been fired or not hired due to a physical impairment. However, the ADA Amendmentws Act of 2008 completely changed this. Congress passed this new piece of legislation, which essentially means that a person cannot be excluded from the definition of being disabled, even if he or she takes corrective action to control their disability. So in essence, this means that if an individual uses medication, medical supplies, prosthetics, or other assistive technology to control a disability, this does not preclude them from filing a lawsuit under the ADA Amendmentws Act of 2008. Also, under the 2008 ADAA, persons with mental or psychological disorders, such as schizophrenia, are protected. Additionally, individuals cannot be discriminated against if they have a known association or relationship with an individual who has a disability. So, for example, if a law enforcement employee is married to someone who has HIV, he or she might have a legitimate lawsuit if it can be shown that an employer was in any way discriminatory. Of course, it must be shown by preponderance of the evidence that the employer knew of this relationship and discriminated against an employee based upon his or her association with a disabled person. Obviously, this may be difficult to prove, since it is often difficult to ascertain the motives of an employer. It is important to note that the 2008 ADAA does not give all disabled individuals unlimited authority to sue their employers. For an individual to have a legitimate case A plaintiff must be able to demonstrate that he or she can perform the essential functions of a job either with or without reasonable accommodation. There are some instances where an accommodation may not be considered reasonable if it imposes an undue hardship on an employer. For example, an employer is under no obligation to grant unpaid leave of indefinite length as an accommodation for a disabled employee. This is usually covered by long-term disability plans as well as workers' compensation plans. Interestingly, a law enforcement agency's obligation to act reasonably increases with its size. The reasoning behind this is that smaller agencies are less financially able to make reasonable accommodations. Under the ADA Amendments Act of 2008, employers can only require applicants to undergo a medical examination after a conditional offer of employment has been made. The reasoning behind this is that it makes the hiring process much more transparent, which enhances the ability of courts to ascertain whether or not a bona fide case of discrimination based upon a disability actually occurred. It is worth noting, however, that the Equal Employment Opportunity Commission does not consider a physical agility test to be a medical examination. Having said this, if a prospective employer utilizes any form of a pre-employment test, whether it be a physical agility test or even a written exam, the employer must be able to show that the testing used is job-related as well as a business necessity. Also, it is very important to note that the ADAAA has a ban on medical examinations, and they're only permitted to put this ban during the hiring process. So, an employer may insist that an employee who is returning from disability status submit to a medical examination before returning to active duty. While there is no question that the 2008 Americans with Disabilities Amendment Act made it easier for individuals with disability to sue their employers, it should be noted that this law does not protect individuals because of homosexuality, bisexuality, being a transvestite, pedophilia, exhibitionism, voyeurism, compulsive gambling, kleptomania, pyromania, or substance use disorders resulting from current illegal drug use. An alcoholic is protected, but not if his or her current use of alcohol interferes with the performance of the job or poses a direct threat to the property or the safety of others. Generally speaking, an employee who is an alcoholic must make efforts to stop drinking in order to file a lawsuit under the 2008 ADAAA. After all, it would hardly be fair for an employer to have to tolerate an employee who routinely comes to work drunk and disrupts the day-to-day operations of the agency. Employers can prohibit the use of alcohol in the workplace and can discipline, discharge, or deny employment to an alcoholic whose use of alcohol adversely affects job performance or conduct. Having said this, it is important to point out that law enforcement employees tend to use alcohol at higher rates than the average person. The literature indicates that this may often be a coping mechanism. Given this, if an employee's use of alcohol begins to interfere with the fulfillment of his or her duties at work, an employer should realize that this may be a bona fide disability that needs to be treated with care. This is understandably a sensitive issue for both the employer and the employee. Obviously, employers and criminal justice agencies cannot tolerate their employees to work intoxicated. Can you imagine a drunken police officer aimlessly patrolling throughout the city? At the same time, though, what if the job itself may have created this problem? Again, this is a difficult dilemma and one that cannot easily be summed up in a 15-minute presentation such as this. If an employee or an applicant with a disability feels he or she has been discriminated against, the plaintiff must file a complaint to the Equal Employment Opportunity Commission within 180 days of the alleged discrimination. The EEOC will either take up the case of the complainant or issue a right to sue letter. Since the 2008 ADDAA is a federal law, the plaintiff will file his or her lawsuit in a federal court. Of course, it is worth noting that the vast majority of states have passed statutes similar to the Americans with Disabilities Act of 2008. Currently, 47 states offer protection in this area, so an employee may also file a claim in a state court. It is important to mention that employers cannot institute policies where they disregard certain types of disabilities. For example, it would be against the law for an employer to exclude all applicants with HIV. Each candidate must be evaluated on a case-by-case basis. Some employers give applicants job-related tests. In fact, this is often a fairly good strategy that may help protect employers against discrimination lawsuits based on disabilities. So long as the test is fairly applied, it is likely to limit an employer's liability. So, what do you suppose happens if a police officer is critically injured during the course of his or her 8-hour shift? Is the employer obligated to restructure the officer's job? For example, does the employer legally have to give the injured officer a desk job? The answer is no. The courts have held that one of the essential functions of being a police officer is to be able to make a forceful arrest. If a disabled employee is unable to do this, then there is no obligation for the employer to offer light duty to the officer. This is a harsh reality, but it is the law, and unfortunately for police officers, it is unlikely to change anytime soon. In the case of Simon versus St. Louis, an appellate court held that a paraplegic could not make an arrest. Hence, the employer was not under any obligation to provide accommodations for this employee. While the courts have held that an essential job function of being a police officer is to make an arrest, what about those criminal justice jobs such as being a probation officer or a correctional officer? Generally speaking, it is a good idea for employers to identify essential job functions. This is technically not required by the Americans with Disabilities Act of 2008, but if an employer carefully lays out the essential job functions, this will be very helpful in determining whether or not an applicant or employee is a qualified individual with a disability entitled to the protection of the ADAA. Also, during a job interview, an employer cannot ask a prospective employee questions about a disability. Interviewers should be trained to ask questions which are related to the essential functions of the job.